This is Michael Popok, Legal AF. Let me give you the timeline now for the trial of Donald Trump in the D.C. election interference criminal case by Jack Smith. Now that we finally have a ruling by the D.C. Court of Appeals, 3-judge panel unanimous against Donald Trump, finding that nobody named Donald Trump or any other occupant of the presidency has absolute presidential immunity to commit crimes while in office. That's a good thing in our constitutional republic. And in a 57-page ruling, we've got the decision of the D.C. Court of Appeals. Now, let me tell you what the timeline is and how it impacts the other trials that you are concerned about. Now that we have this ruling, the judges also have, the 3-judge panel basically have cut the legs out from under Donald Trump and are not really giving him the time to seek a further what's called en banc appeal to the full 12 members of the D.C. Court of Appeals, because they've only given him until the 12th, right, which is just another 5 days, to file a appeal to the United States Supreme Court. So he has no time in the middle to seek the en banc decision because they gave him a short amount of time. And they're going to currently stay their decision and not return the mandate, meaning the direction to the trial judge, Judge Chutkan, to get the case started, to return the case to the trial judge. They're going to wait until the 12th. If the 12th comes and goes and Donald Trump has not filed his appeal, they are going to instruct the judge through a mandate, the trial judge, to get back on the case, to take the stay off the case and reset the case for trial, which is really what's left here, that and trial preparation. We know that Donald Trump is going to do it because, we already know that Jack Smith wanted to take the original appeal directly to the United States Supreme Court. And the reason we're even back at the D.C. Court of Appeals is because the Supreme Court basically sent it back to them or said, you know what, do your D.C. Court of Appeals intermediary appeal first before you get to the Supremes. We're here, we're waiting for you. So, of course, the D.C. Court of Appeals, led by Judge Pan here, knowing that their bosses at the Supreme Court are waiting, have given Donald Trump a very small window of time to file this appeal. Which is sort of ironic because the D.C. Court of Appeals took like 5 weeks to issue this ruling. But in any event, they're back on track now. The trains are running on time. And so what is the next step? So Donald Trump will file his notice of appeal, his emergency application for appeal. It's an interlocutory appeal up to the United States Supreme Court. First stop, let's say that happens on the 13th. It can happen earlier, but by the 13th of February, they usually do it with full sort of a brief attached as opposed to just a simple notice of appeal. It's got a full brief attached to it. I guess it'll come out with John Sauer, this lawyer that just lost badly with the United States, with the D.C. Court of Appeals for Trump. And that will go first stop to the Chief Justice of the Supreme Court, John Roberts, because he's sort of the administrative duty judge that sits over the D.C. Circuit. Right? So he makes the decision. He can do it on his own. Nope, I'm not staying this case. I'm rejecting the appeal. You can do the appeal at the end of the case. I don't think we have jurisdiction. He can do all of that himself, but he's not going to. Let me just manage expectations. There's been so much attack on the use of what we used to call the shadow docket, where one judge, one justice made the decision on their own without reference to their fellow colleagues. It's not going to happen here, especially on an issue this important. So he's going to do two things. I am sure. He is going to do an administrative stay for a short amount of time. Don't let that raise your blood pressure or give you agita. Okay? It's expected. He's going to give a short administrative stay, maybe a week or two, whatever it's going to be, to give time for full briefing. And he'll refer it to the full 9 justices of the United States Supreme Court for determination on this full briefing schedule. So he'll set a briefing schedule and he will stay the case, meaning it's still not with Judge Chutkan. It's still up at the appeals level. Donald Trump doesn't have to work on the trial yet, but will signal that the Supreme Court wants a fast briefing schedule. So we need to look first at what John Roberts does in terms of stay and briefing schedule to know how serious they're taking this, and we'll know right away whether the United States Supreme Court believes it as important as we do here on Legal AF and on the MeidasTouch network, that Donald Trump be tried and there be a verdict by a jury, thumbs up or thumbs down on criminal conviction, before the November 5th election. We'll know within a day or two of the 13th of February. We'll report it here on Legal AF. You can come back here. We'll have it all ready for you. Okay. So February 13th or just before, we'll get a brief by Donald Trump sent to Chief Justice Roberts. Chief Justice Roberts will enter likely an administrative stay for a short period of time and give full briefing. Let's say that full briefing takes us to the end of February with oral argument in the beginning of March. I think this is realistic. If we see something different and it slides and they want to cut Donald Trump a break and get this thing closer and closer to the election, then you'll see different dates. But I think we'll see dates that'll take the oral argument into the beginning or middle of March. And then we'll get a ruling. Now, there's no timeline. The Supreme Court, as we all know now, operates on its own timetable. So we will get a ruling from them either in the month of March or let's say the month of April. I don't think it goes much beyond there. If we get a ruling, let's say, at the outer boundaries of April, that's still plenty of time for now. If the decision is that the 3-judge panel and their 57-page decision and the legal analysis and underpinnings of it, which are rock solid, I'll do separate hot takes on them, is affirmed by the United States Supreme Court, which I believe it will be, that even this right-wing Supreme Court, 6-3 on the right, is not going to want to set a historic precedent that lives with them as a scar on their records, that they were on the United States Supreme Court that made the decision that former presidents have absolute immunity to commit crimes while in office. I don't think that any of them want that to be, at least the majority don't want that to be their legacy. So let's assume that the ruling is against Donald Trump, which I feel very confident that it will be on this particular issue. Then it would go back in April with a mandate back to and be reassigned back, if you will, to Judge Chutkan, the trial judge, right? All these appeals are going on above her. It now returns to the day-to-day of the trial. Judge Chutkan would then hold in April, let's say mid-April, early April, as soon as she can, a hearing with the lawyers for the Department of Justice on one side and Trump on the other, and reset the trial. Now, we know where her head's at because she originally said that 7 months of trial preparation when she set the trial was enough. Well, Donald Trump got about 4.5 to 5 months of trial prep in before he filed his notice of appeal and stopped the case. So she's got to add a couple of months on to the back end of April. So now we're talking about June, maybe July. June, July now is the period that we'd be looking for the actual trial of Donald Trump on the 4, put an asterisk in that for a minute, the 4 conspiracy counts against him brought by, and he's the only defendant in the D.C. election interference case, in front of a D.C. jury in June or July, which is plenty of time under how fast and the velocity at which federal cases move for that trial to be concluded before November 5th with either he's convicted, Trump, or he's exonerated. I don't know which yet, but given the weight of the evidence, you know where my heart is at and my head follows. So that is June, July. Now, and we're now beyond the Supreme Court. Supreme Court's already ruled. They're in our rearview mirror, and we're just chugging along towards that verdict. That's what I believe now is going to happen. If that's the timeline, right, and the trial of the D.C. election interference case is not going to happen until June or July, we've got a February 15th hearing in New York with a state court judge, Judge Chutkan, and the criminal defense lawyers for Trump and the Manhattan District Attorney's Office over the Stormy Daniels hush money cover-up business record fraud case against Donald Trump, which is like 30-plus counts of felonies in New York. That case could go in March, which is what we've always thought, like in the third week in March. But we're going to know better on the 15th of February whether Judge Chutkan is going to yield and leave space for the Judge Chutkan, bigger, badder federal election interference case dealing with Jan 6th to go forward, or he's going to try to slide his case in March, April, and May, and then see what Judge Chutkan does in April. Does he sit on the sidelines and hold his case in abeyance? I think there's going to be a phone call here. And there had been a phone call already between Judge Chutkan, the federal judge's chambers, and the chambers for Judge Merchan a number of months ago that we reported on in Legal AF. And the conversation between the staff is going to go something like this, and maybe between the judges. And they're allowed to speak under the judicial canons for the administration of justice when they have the same defendant in front of them. It's going to be like, hey, I could go in March, but the state court case is going to be a number of months. It's not as fast as the federal case. Could take a month to pick a jury in New York. So realistically, I could see Judge Merchan saying, let me give you my timeline. If I start in March, I'm not going to be ready by the time you're ready to pick up the case in June or July. What do you want me to do? And Judge Chutkan might say, who's already on record in another recent case as saying she's ready, willing, and able to cancel her July vacation, because they all get vacations, and they usually go away and do things in the legal profession, teach law students and foreign lawyers about comparative American law, that kind of thing. Chutkan's canceling July. So I think the conversation with Chutkan's going to be, listen, I would like you to do me a favor. Do me a solid here. And don't set the Stormy Daniels case. I know we're all excited about Stormy Daniels. I've got colleagues who worked in that office on Legal AF. But I think the bigger case that's more important to the American democracy and electorate is to have the Donald Trump election interference Jan 6 case go first and have that be what the American electorate is voting on November 5th. So I think Merchan yields if Chutkan asks him to clear the space to allow for the July trial. Now we're rolling the dice here a little bit, because that assumes that the United States Supreme Court is going to make its final ruling, and it's going to be against Donald Trump by, let's say, April. If they don't, and they hold it, look, Merchan can always slide back in. Just because he's holding a February 15th date to set the trial, he could say, he could roll it and say, listen, ladies and gentlemen, I'm not ready to set the trial yet. I want to see what's going to happen with the Supreme Court decision on the D.C. election interference case, which has not yet been set for briefing. Because it'll only be 2 days after. He might have that data point. Judge Merchan may have the data point from Chief Justice Roberts about the briefing schedule for the other case, this case of the immunity case, but he's not going to have the full response, right, of the Supreme Court. So I'll have to factor that in. So if I'm Merchan, I probably kick off this hearing on the 15th and push it off until he gets more data. And then he might have already spoken to Chutkan by then about what she wants to do. Because I think she's running the show here, right? She is a federal judge with the bigger, badder case, can Bigfoot Merchan and tell him, I'm taking this case. So we're going to have to watch this very, very closely. So while we want he to be tried anywhere at any time on a crime for Trump, I think the better case is to give Chutkan the kind of give her wide berth to try her case and be respectful of it. And then Merchan can always jump back in the New York State Supreme Court case and say, it looks like it's not really happening with Judge Chutkan. I'm going to set my trial for April or May. And he's got plenty of time there too. It's just that his track is longer than Chutkan's track. Chutkan can get her case done with the jury in probably 2 months. And I don't think that's possible with the Stormy Daniels case. Given the amount of counts and the witnesses and all of that, I think it's going to take a bit longer. But we'll continue to follow. Now you've got the outlines of what's going to happen. Now that we've got the trigger event that we needed, which is the 3-judge panel D.C. Court of Appeals happening, the unlikelihood, almost impossibility of there being another layer of D.C. Court of Appeals procedural work with the en banc, all 12-judge panel hearing the case. They're not going to. The United States Supreme Court getting it by the 13th of February, the ruling that we're expecting by Justice Roberts to stay temporarily the case and set a briefing schedule so that the immunity issue is fully heard at the full United States Supreme Court. That happening over March, beginning of April, then a final return to Judge Chutkan in April, who sets the trial for June or July. And then we have on the sidelines Judge Merchan in New York, kind of waiting patiently to slide in when he can, but giving Judge Chutkan a wide enough berth to try the bigger case. And then we've got, finally, I'll end the hot take with Judge McAfee in Georgia, who's also going to be holding hearings in February, also on the 15th of February, where he's going to have to consider when he's going to set his trial against Donald Trump, which we've always heard is going to be in the later summer. But we know that case is an 8 or 9 month runway case. So when it starts, it's not going to end for 9 months. It'll never be concluded in time for people to know whether Donald Trump is a convicted criminal or not, at least in the Georgia case. That's where that's where we are with my breathless explanation of the impact of yesterday's ruling and what it means for the trial calendar for Donald Trump in this update. We'll continue to follow it on Legal AF, the leading podcast at the intersection of law, politics, and justice, on Wednesdays and Saturdays at 8 p.m., only on this YouTube channel, the 2 million strong MeidasTouch YouTube channel. And then on hot takes, just like this one, about every hour by the leaders of Legal AF. So if you like what I'm doing, thumbs up for me. That would be helpful. Keeps the network on the air, keeps me on the air. And until my next hot take, until my next Legal AF, this is Michael Popok reporting.
Love this video? Make sure you stay up to date on the latest breaking news and all things Meidas by signing up to the MeidasTouch newsletter at MeidasTouch.com/newsletter.